So it seems that we are online.
Yes, Prof. We are online in LinkedIn.
Okay. Okay. So welcome to our conference, and I say that Olga, you can start. Okay.
Great, thank you very much. Is it possible to
Yes.
share? Great.
Or this? No, wait. This. Okay.
Perfect. Thank you very much. So, yeah, thank you very much for having me here today. My name is Olga Tsopoulou, and I'm a researcher at the Law, Science, Technology and Society Research Group and at the Health and Aging Law Lab at the Free University of Brussels. In case I speak too fast or something is not clear or my sound is not good, please interrupt me and let me know. The title of my presentation today is Don't Get Me Wrong, and we're going to see and discuss about the EU data protection legal terminology inconsistencies and their impact on enforcement. I just want to say that my background is both in law and linguistics, and today we will take a dive more into the linguistic and terminological aspects of EU data protection law rather than the legal aspects. So my overview of the presentation is actually very straightforward, no surprises. We will start with a background and motivation, state of the art, my research questions, the methodology I used, the results of my research, and a discussion, and some concluding remarks. So a little background for possibly those, I don't think there will be many, for those who are not familiar with data protection law, that the Data Protection Directive was the predecessor of the famous GDPR, aimed for some form of approximation of the data protection laws across the EU. And one way to achieve this was also the creation of the Article 29 Working Party as a coordinating body among the data protection authorities in the different member states. The European Commission, while they were preparing the discussions for the review of this legislation and the creation of the data protection and the GDPR, they basically they created a report where they suggested that the application and interpretation of the data protection law remained divergent by the national data protection authorities, despite those efforts for approximation. And this happened in 2010, and today in 2018, we have the General Data Protection Regulation, which actually aims to have this the so-called Europeanization of data protection law by harmonizing data protection law across EU. And even though we see that this is the GDPR ambition to harmonize a so-called highly fragmented data protection framework across the EU, and now we're already 4 years in the legislation, we see that or actually I should first say that to do that, again, one idea was to reinforce the role of the national DPAs and to also strengthen the role of the coordinating body, replacing the Article 29 Working Party with a European Data Protection Board to help ensure cooperation and consistent interpretation. However, that's what I started saying before, is that we see that this fragmentation actually persists. And to an extent, based on what we see also from the reports from the European Commission, is that it's caused to by the differences at member state level and the inconsistencies between guidelines published by the EDBB and the guidance issued by the DPAs. And the Commission goes as far as to say that this could even ultimately endanger the exercise of the fundamental right to personal data protection. So I was thinking that I would like to study a little bit more, investigate a little more why this problem still persists from a linguistic and terminological point of view, taking into account that we know for quite long, as long as the EU exists, the peculiarities of the EU multilingual environment, but also the fact that some DPAs also have raised issues regarding translation of documents they sent to EDPB, as well as the proofreading of EDPB translations of adopted documents. My motivation, therefore, is that even though such peculiarities are particularly known with respect to the legal text, we have they are less investigated when it comes to documents supported to the enforcement and interpretation of EU law, for example, administrative and policy documents. And the DPP documents are primarily regarded as such, administrative and policy documents, which must ensure a high degree of accuracy and precision, but at the same time without being expected to go through the same high degree of drafting, revising, and translating scrutiny as legal text would do, which kind of is a bit difficult to see how this could be implemented in practice. Thus, the aim of my paper is to explore these potential terminological inconsistencies, which have already been observed in other fields of EU law, this time for EU data protection law, by choosing and studying a specific term as appearing in these non-stricto sensu legal documents. The term I have chosen is processing of personal data, and the case study was inspired by actually another paper, another lengthy study I conducted with a colleague of mine almost 3 years ago at the beginning of the pandemic, where we studied different documents, different opinions and documents and guidance drafted by data protection authorities with respect to the measuring of body temperature in the context of COVID-19 pandemic, where we saw that there was a lot of divergence with respect to what constitutes processing and what is not processing under the GDPR. And some other reasons why I chose this term is that because it's a central term with a formal definition that can be found in the GDPR, but as I said, divergent interpretations. It's rather broad on purpose, but also with, it seems that the legislator has intended some kind of limit, because we see an intention to find out what is not actually included in it. And it originates from from another specialized field, the ICT field, information communication technologies field. So that makes it semantically ambiguous, but also carrying a significant legal meaning. With respect to the state of the art, of course, we know that the EU multilingual environment is characterized by language diversity, but at the same time language equality. And there is this rather big ambition for one law, one interpretation that we cannot be sure that actually has happened in practice, or it's still in process of happening, and we don't know how actually desirable this is or it's not. But what we know for sure is that based on research from other scholars is that terminological incoherence that can happen due to incoherent translation techniques is one of the most serious impediments to the approximation of EU law. And what that means is that we need interlinguistic concordance and interlinguistic consistency. In other words, the same words for the same concept across texts in the same branch of policy, in order to make sure that we do what we can to ensure legal certainty. And one way to test whether this actually happens in practice or not in multilingual environments is based on Robertson, the semiotic analysis of terms, and the comparative analysis of terms among the various language versions. And that's exactly what I'm doing in my research. And thus, I'm coming to my research questions. The first one is whether there are indeed inconsistencies in legal terminology in the documents issued by the European Data Protection Board in English as compared to other translated versions. And the second question is what can drive those inconsistencies, if any, in legal terminology in the documents issued by ADPP in English as compared to the other translated versions. With respect to my methodology, as I said, my starting point was the term processing as it appears in the GDPR definition. My conceptual framework is I understand this term as a sub-technical term as part of the conceptual framework introduced by Marin, Andrea, and Chang Ignacio. And I also use the Kerman's framework of units of understanding and translation units because if you notice in the definition of GDPR, there are many co-references with respect to the term processing. I have created a primary corpus of 26 adopted or under public consultation guidelines, and a parallel corpus of the translation of those documents, if available, selectively in Greek and French, which are two languages I thought I'm able to work on, having some trust on myself. And all this is built in MaxQDA to perform the qualitative comparative analysis needed for the research. And I also have used the Sketch Engine's Thesaurus feature to study the term processing outside the EU specialized context, meaning to understand how this sub-technical term is used in everyday language and if this has an impact on its specialized meaning. There were some limitations, including that only publicly available documents were those I could study, for example, not internal processes. Not all translations were available. Not all translations, actually, none of the translations was proofread, although this is a formal requirement, and the documents have been for quite some time on the website of the EDPB. And of course, there are also other factors that can influence the quality of translation and the quality of the translator's work, which I didn't take into account when I was doing my study. So with respect to my results and discussion, as we see, it is very important to also take a look in the formation of the term processing in the EU legal context. We see that when the term was initially in the data protection law context, we see that the term use is favored as compared to processing. And later we see it in the 1992 explanatory memorandum of the Data Protection Directive proposal that the legislator's intention was that the definition of processing is an extensive one as it covers everything. What the CJEU has said about it is that, yes, it covers a lot of things, and they give quite some, and there are quite some examples, the loading of personal data on a website, the collection of personal data from the public domain, and so forth. But it's also a number of things that are not covered. For instance, the legal analysis as a process controlled entirely by human intervention, or a request for a transfer as long as the transfer of data is not completed. And as I said, the Article 4.2 GDPR is where we find the definition of processing, and there we also see that this definition has something very interesting. It has a multitude of other terms in order to explain this one term, as we will also see in the next slide. And you see here in bold. And what I did here, this is from the Sketch Engine, is that I tried to see what kind of synonyms are the most frequently found with respect to processing in everyday life use. And here you can see that some of the words that actually are being found in the definition in GDPR are not included here, whereas others are, like storage and distribution. With most interesting the term transfer, which, as we know, can be understood as processing, but actually it's not included in the official definition. Here you see all the words as found in the GDPR definition on the left that are used to the terms that are used to explain the term processing. And on the right, you see the Greek and French versions and comparison. I will bring a couple of examples to show they were not just to first mention that there were not, with respect to my first question, not so many inconsistencies. But those that I found were actually quite interesting. For instance, in the Greek version, we do see that the term recording is being translated in two different ways. Not always the term used in the definition is being used. And the same with the disclosure by transmission, that sometimes they don't use the disclosure by transmission, but the disclosure or transmission. Which could also create some confusion with the dissemination or otherwise making available. And answering my second question, because I see also my time slowly is up, the drivers for terminological inconsistencies, I figured that I wanted to address two, the extra-linguistic, which is usually what's mentioned by the authorities, the lack of resources. And that means that translations and communications used with the EDPB can also, in documents used with EDPB, could be made by non-experts. The time urgency, we see that there are so many issues that have to be addressed quite fast, and the EDPB and the data protection authorities have the pressure to produce documents in very limited amount of time, but also the different legal tradition. Now, the interlinguistic purposes for such terminological inconsistencies could be that we speak about a very broad definition of processing and a non-exhaustive list, which means that actually this could also exclude the possibility, mean that these are actually not inconsistencies, but just a different term. And the fact that there's so many examples, I'm finishing, in the definition, and that could create even more interpretative and translatory complexities. And something very interesting for data protection law is that the dynamicity of terms and definitions, as well something in general with respect to EU law, that we see that the official resources used by translators for revising texts are actually not always up to date. And by that I conclude. So we saw that there is still fragmentation. This can be justified by a terminological point of view to an extent. And of course, there is still space for more research. For instance, do we need a standardized procedure in order to avoid these terminological inconsistencies? And if we could extend this framework also to other legal terms from the definition list of GDPR. That's all. Thank you very much.
Thank you, Olga. And now, Arletta.
Hello, just give me a little second. Hello, I'm trying to put my slides up. I'll do my best to be as quick as I can. To give me a little moment. Obviously, now the wonders of MacBook, I thought I could have just shared my screen like I could do in Zoom, for instance. So allow me. Obviously, like I will do my best to obviously wrap up the presentation relatively quickly. It's just processing. Yeah, I've got it.
Yes.
Can you see it?
Okay, perfect.
Brilliant. I'll switch off my camera because I'm going to obviously use my speech, because I tend to talk too quick and too much about the concept. So hello, thank you very much for inviting me to this presentation. I'm going to present you today with a little short overview of what I'm doing for my PhD thesis. So obviously my PhD thesis is about competition law and privacy protection, and I'm trying to really define the relationship between those two legal orders. So basically my research is very doctrinal. I do have a look at the cases surrounding the concept, and I'm trying to really decode as to whether we can potentially achieve a consensus or a nexus between competition law and privacy. So obviously, before we start, a little overview of where is the problem. So obviously we know that we live in a digital era. Everything is generally happening online. We use Facebook, we use Twitter, Instagram, LinkedIn, and all of these websites. They do collect our data, and they do collect it for very unprecedented amount. So how did that really shape through the EU legal practice? So empirically, we start with the Asdev ex Quitas case in 2006. We had for the first time really mentioning that any possible issues relating to sensitivity of personal data are not as such a matter for competition law. However, obviously that was back in 2006, so many things have changed ever since. So then when we do have a mergers of Facebook and WhatsApp and Microsoft and LinkedIn, for the first time, we really have a mention that is really potentially possible to merge competition law together with privacy protection. However, what we had achieved that privacy was seen as non-main but important parameter in competition. So eventually this really leads to lots of confusion, and we really don't know how to navigate that through. So having a little words about what happened in the Facebook and WhatsApp and Microsoft and LinkedIn mergers, really the commission did looked at how the market is going to function. They never really pay too much attention to obviously the data protection and whether accelerated use and combination of data sources could potentially result with establishing the monopolists. So eventually, after all these years, so we have obviously asked Netflix quit us, so we had it refused to acknowledge competition law together with data protection. And then obviously we had those two mergers when we had said that obviously privacy is a non-main, however, it is an important factor because it was to a certain extent we could acknowledge it as a quality component. We still never had a consensus as to what was the optimal method of evaluating data and EU competition law. However, really from those three cases, it was really, really apparent that EU competition law could support the prevailing approach and could assess decisions involving personal data through the spectrum of protecting a competitive balance in markets. But then obviously things have changed. We have the famous Facebook case in 2019 when we had for the first time mentioned that, yeah, so potentially any breaches to GDPR could, to a certain extent, be seen as infringing competition law, and this is really how our debate has sparked. And eventually, last September, we had AG Rantos telling us that any incidental infringement of GDPR could, to certain extent, lead to also infringing competition law. So even though we have all these cases, we really still are unaware as to what extent competition law and privacy protection could go hand in hand. So really the next question was to conclude as to whether we should have an exclusionary approach or unitarity approach. So when we really do look at the literature, we can recognize two opposing views on the intersection between competition and privacy. So firstly, we have obviously famous quotation from Esquita's case, which was the ratio of this case, to acknowledge that obviously data protection is beyond consideration of competition law. This is where we had the court really rejecting the intersection between competition law, and this is where we see that, to a certain extent, obviously, privacy and competition law are completely two different. They are obviously two different legal orders, and they should be treated as not complementary in their nature, and also not overlapping. Really, the central argument remaining that incorporation of privacy concern and competition law cases could potentially create confusion, especially when we would look at the consumer welfare standard. However, on the other hand, we also have integrationist approach, which they'll accept incorporation of privacy into the long-standing competition law framework. This is where we consider that consumer welfare could be improved by taking into account both price and not price factors. Obviously, not price factor will be privacy in this respect. When we do have an evidence, when companies compete to offer more or less privacy to end users, then obviously the integrationist approach could consider if privacy-based competition might be potentially impaired. So how to really demonstrate that effectively. If we really consider a hypothetical merger of two internet-based companies, if they do compete to offer different level of privacy pre-mergers, the assessment could potentially consider if the merger substantially reduce privacy options available to consumers after that merger. And then obviously the integrationist approach could then assess whether privacy as quality reduction could lead also to reducing competition. However, obviously, when we do not recognize privacy as a quality competition between merging parties, then obviously the integrationist approach would consider that any privacy-related concerns are obviously seen as being outside the scope of competition law assessment. But really, we still have these two opposing yet somehow complementary theories, and we do really have a question as to what is the eye of the problem, how we should get through this problem. So essentially, the advent of big data has fueled the innovation, we know that. And we also know that just because the data is being fueled, we have new products, services, but also we are potentially exposed to problems with obviously protection of our privacy, because obviously due to the practices of large digital undertakings, we have unresolved privacy problem. And why is an unresolved privacy problem? Because there is a problem of a notice and consent recognized by the GDPR and obviously the business model of large digital undertakings, to the extent that we blindly say yes to them to access Facebook, Instagram, or any other social media. But on the other hand, we are often unaware as to what is really the nature of using those programs and those services. And Facebook case from 2019 really serves as the best example for that, on the basis that German Facebook users were unaware of the fact that the Facebook was merging their data on Facebook and also outside of Facebook from any different third parties that were complying with Facebook business tool. However, at the end of the day, data protection and competition policies, they do share a concern, the fundamental similar concerns, and also similar remedial approaches with to how to mitigate unfairness by introducing and imposing obligation on those with market power. Really, the goal will be to prevent imbalances between individuals and different powerful companies. And however, here there's a little problem, because data protection legislation could offer only a partial response to exploitation of personal data, because data protection law arguably does not recognize the long-term harms to platforms users, which obviously include the special responsibility that could ensure the position of power of some digital platforms. So having considered that, I came to the conclusion that we really do have problem, which is the effect of collection of personal data. So at one hand, we obviously have competition policy, on the other hand, we've got the data protection policies, and they both appear to be interconnected with the competition law problem, which are recognized as a market failure, and various behavioral and informational problem, which also leads to another market failure. So really, my presented model will map out the intersection between data protection and how they interact. And we can see obviously that just because we have recognized two market failure, which is obviously the market power and information asymmetry, it really makes it difficult to deal with abuse of dominant position. So obviously, firstly, the economic characteristics of online digital platforms and their business model could allow for unprecedented data collection, and they all have obviously the impact on us, the digital users. And how does it work in practice? Because in practice, we do not pay any price for using online sources. However, we do actually give away our data, which is obviously recognized as a monetary payment for them. And just because there is such a broad access to our personal data, that increases barriers to entry that could further entrench the economic power of digital firms, and also could allow them to exploit the information asymmetry between us, the consumer of online platforms, and obviously the online service providers, which are obviously manipulating us. So that's really just to conclude that obviously we do have those two obviously, but however, that really shows us that unquestionably competition law could have a role in protecting our privacy online, even if we assume that privacy itself might not be easily reduced to a commodity on the markets. The privacy protection should be recognized at least as an element of users' privacy, because obviously the recent research of, for instance, Professor Ackman, they do show that users are indeed caring about their digital privacy. So how can we achieve this nexus? I assume that we can follow the risk-focused approach, which could potentially bring some sort of clarity between the intersection on competition and privacy. I assume that when we do follow a risk-based approach, it will focus on creating a quite much integrated and holistic approach, because that would allow us to respect boundaries of competition law and boundaries of data protection law. Why I labeled it as risk approach, and this basis that the risk of consumer-related harms will be recognized by both the markets and the consumers. And just because we do have unresolved market failure problems and there is a tendency to exploit users, we do have the deficit in competition law and data protection law. So essentially, the risk-focused approach could consider those problems as being mutual. And they both could be answered, obviously, by looking at competition law and data protection altogether. So what can we potentially look at? We can potentially look at as the kind of data being collected and proceeded, and also the fact that the data could have been collected and proceeded unlawfully. So firstly, with the notion that all data is potentially we recognize those 5 V's, but essentially when we do collect the data is processed, and when it's processed, obviously it allows to straighten a dominant position of undertakings. But also the secondly is that misleading practices could be potentially given a rise to preservation of gatekeepers' dominance. So here, obviously, the caution approach will be to see a competition law would intervene in the problems that harm the competition and they directly harm the competition in the relevant market. Obviously, to consider the privacy as a competition dimension, we need to consider that services are offered at zero price in exchange of personal data. And a particular problem is that gatekeepers will always try to get a higher attention and the user's consent. So this in turn will potentially lead to degradation of offered service or product's quality, which obviously could then introduce poorer privacy protection. So how can we conclude it? So obviously we can conclude that there is our overlapping concerns for both competition law and privacy. However, at the sense, we should not even consider that competition law should be extended to cover any possible data protection problem, because obviously competition is a tool to safeguard obviously the markets, and which leads to my second conclusion is that competition law should only intervene in conduct involving privacy-related matter when they are seen as a theory of harm of competition law. Thank you very much. I will try to remove that from the studio now. So thank you very much for your attention.
Okay, perfect. Thank you, Letta. And Marco, are you here?
Yes, can you hear me, Prof?
Okay, perfect.
Okay, hello everyone. Good afternoon. For the first, thanks to the organizer for this very interesting conference, this opportunity. I will share the slides now. One moment, please. Okay. I hope they work. Okay. Prof, can you see the slides?
Yes, now I see.
Yes, perfect. So the title of this abstract is NFT, Privacy and Data Protection. I'm Marco Lagna, I'm a trainee lawyer at Perani Pozzi and Associati boutique law firm in Milan. I'm dealing with privacy, personal data protection, and civil law issue, primarily in the area of new technology law. So we'll start. The concept of NFTs originally comes from a token standard of Ethereum, aiming to distinguish each token with the distinguishable sign. This type of token can be bound with virtual digital properties as its unique identification. So NFT is a unique token that cannot be exchanged like for like, and that making it suitable for identify something or someone in a unique way. Well, once an NFT has been generated in the blockchain, it is very difficult to block its diffusion, even legitimately, especially if the identity of its owner and or creator cannot be traced for the privacy reasons that characterize the underlying technology itself. But how to block this diffusion? The way are for example, two. With burn. So with burning an NFT, is similar to effectively destroying it. While technically NFT always remain on the blockchain, on the ledger, we can remove one from circulation by sending it, for example, to an inaccessible wallet address, not always, obviously, with any fees. The second solution is the list. When removing essentially an NFT from an exchange, but with fee. That is, for example, the gas fees. NFT community often encourage holders to delist NFTs ahead of major announcement, for example. In this abstract, we will attempt to briefly explore the issue between the use of NFTs and blockchain technology and the prerogative under the GDPR for the processing of personal data, as well as how these technologies can lead to copyright and intellectual property infringement, negating the need to protect the exclusive rights holder. But what about NFT and copyright? Regarding copyright, the biggest issue may concern the digital content, which is the subject of the NFT. For example, creating an NFT representing a copyrighted work poses issues in relation to the information storage on the blockchain, on the referred blockchain. There is also an issue related to the dissemination of such content, subject of the token. The amount of information contained in the blockchain is stored not in one device, but in a number of different devices, all connected to each other according to the technological features of the blockchain itself. NFT, in addition to having generated a very strong interest in the crypto market in general, have been a real revolution in the field of copyright, in particular in the field of the so-called crypto art. Currently, according to the legislation in force in Italy, the author of an intellectual work protected by copyright enjoys two different types of rights: the moral rights and the patrimonial rights. Moral rights give to the right holder a special form of protection, which consists of deciding what to do with his work, to claiming the authorship, and opposing any alteration or modification from the work itself. The patrimonial rights are the so-called the economic exploitation rights of the work, which can be translated indicatively into the right to publish, reproduce, communicate, and/or distribute to the public, as well as to grant the use or in toto to third parties. It is important to note that in the context of NFTs, the person who purchases an NFT token does not acquire the copyright to the content that is the subject of the token through its use, but rather acquire a simple certificate that allows him or her to track and prove ownership of the digital copy purchased. The recurring question when discussing art and NFTs, or for the matter, the relationship between the rights of the token and underlying work, the subject so of the NFTs, is where are these works of art essentially? The answer is a bit more complex than one might think and depend on the type of token being created. In most cases, if the object of the token is, for example, a media file, it can be bound in a special file manager, or in a technical proper language, in a peer-to-peer protocol that operates on the blockchain and makes the content accessible. For example, the most diffuse protocol is the EPFS. Of course, what makes the NFT unique is the fingerprint of the token, the fingerprint of the file itself. That is the hash code, which precisely identifies this token, this file. For example, if an unlimited number of NFTs of the same item are sold to very different parties, each of them will own a single copy, but not the underlying original image or file or work art. The latter will remain the exclusive property of the author, precisely by virtue of copyright, with all that this implies. Will then be able to economically exploit his work an unlimited number of times, so being remunerated for the purchase of token and etc. While NFTs certainly represent a new form of protection, they raise a number of concerns regarding aspects of the uniqueness of a work of any kind. It is now common knowledge that any multimedia content can be the subject of a non-fungible token, be it audio, video, or image, for example. There is also no doubt that the NFT and so the blockchain technology can facilitate the management of the piracy phenomenon, for example, given the extreme ease with which digital content can be duplicated by anyone who comes into possession of it. In fact, from this very interesting perspective, blockchain and the use of the non-fungible token technology certainly represent an effective tool for companies to protect their brand. About NFT and privacy, and with regard to the possible issue between blockchain technology uses and privacy, the main problem is in the idea that the blocks placed on the blockchain are themselves protected because they are encrypted, or that the contents of these should not be considered, for example, personal data, as GDPR requires. For these reasons, one could conclude that what goes into a blockchain does not fall within the scope of the General Data Protection Regulation and other privacy regulation. Without expanding and going into detail, we define personal data as any information that directly or indirectly identify a specific individual, a specific data subject. Therefore, it would be necessary to investigate whether the hash, for example, could also identify the owner, the precise owner, or the creator of the token, the non-fungible token, for example, in the same way as already been analyzed for the IP addresses, for example, many years ago. The GDPR aims to protect the fundamental privacy rights. It strives to achieve this goal by giving individuals more rights and more control over their personal data. And additionally, it puts more obligation on the data controllers that shoulders on demands and that controllers can always demonstrate compliance. So the accountability principle. Well, the GDPR is technologically neutral, which means that the GDPR compliance must be ensured whenever personal data of natural persons, so the data subjects, are processed in a structured manner. Consequently, the material scope of the GDPR is also applicable to the blockchain whenever personal data of a data subject are processed. But what might be the friction points between what the GDPR requires and what apply to a blockchain technology, a non-fungible token, for example? First of all, the GDPR assumes that there is at least one data controller, which can be addressed by a data subject, an individual. In contrast to this one-to-one fiction of the GDPR, the blockchain works with multiple players and with the decentralization. This makes the allocation of responsibility and the accountability principle on the blockchain under the GDPR more onerous. For the second, the GDPR grants certain rights, for example, the right to data rectification, etc. Certain rights to the data subjects, which again contradict the blockchain values, since the blockchain is a shared, immutable ledger for recording transaction anonymously and tracking assets and building trust for users, for blockchain users. For the third, another obligation of a data controller is to ensure the privacy by design principle. Simply put, this obligation demands that these principles are taken in consideration in the developing phase of a product. In this way, the GDPR requires to controller to implement appropriate safeguards, and this means that the blockchain itself should respect the GDPR principle, such as data minimization, purpose limitation, but also storage limitation, and that's it. Lastly, the aforementioned issue of whether it is possible to consider information stored on the blockchain as personal data, which, depending on the case of the distributed ledger technology, may also be, for example, public and visible to all users on the chain or not. In conclusion, Given the aforementioned the reasoning, more regulation of new blockchain technology-based tokens and blockchain technology itself and their compatibility with the regulatory framework is very encouraged for us. Specifically, such tokens should be addressed and made compliant with the prerogative of the GDPR. First of all, for example, the privacy by design principle, but also the accountability principle and national intellectual property and privacy regulation. In further, it was certainly be necessary to identify for us, so preferably at the regulatory level, what technical and organizational security measure, but also a contractual measures are needed to guarantee the right of user for privacy and the right for creators for copyright and author protection. Thank you so much for the attention.
Thank you, Marco. And now we have some questions. So, for questions. Okay. Olga, do you think that it's possible to create a single data protection authority? You can read the question here in the down.
Yeah, thank you very much. So I think it's a very intriguing question, and I think it has been discussed also in the before when reimagining how this data protection legal framework would look like at the EU level in order to achieve this harmonization that's actually intended to be achieved. I believe that I would start with say that this would legally need a review of the current legislation and would also require a review both at EU level but also at national level in order to make this actually happen if that was actually the intention. And my second question would be how this mechanism would look in practice, how we would, like if it was to create one single data protection authority at EU level that would be operating for all member states. I'm not sure how this would look in practice. And also when this decision to go down this road would be made, because actually the gender protection regulation has been in force now for quite some time, but I would say, has it been long enough in order to already be discussing of completely reforming this framework that only recently was strengthened and had been provided with the powers that have been provided in order to operate the way it is. Then I was also thinking, would have a single data protection authority at the EU level actually ensure that we have one interpretation, like one body, one interpretation? Again, I have some doubts about it, especially because I was having in mind another system that's already being used in practice, and that's of course in a lot smaller scale. It's what's happening actually inside the EU itself as an ecosystem of different institutions, agencies, and bodies, where we have the European Data Protection Supervisor as a centralized agency for all of them, but every institution, agency, or body also has its own DPO. And we do see that if we take this smaller picture and we bring it in a bigger picture of that of member states, something similar happens there, that even if we have a centralized kind of authority in place, there will always be a point of reference for every single member state in practice. And that's actually not necessarily bad, because we also need to consider what happens to data subjects, and that having more than one data protection authorities in place potentially has as a result that data subjects have more opportunities to exercise their rights in case one of them would fail or would not be working as it should be working. So having more data protection authorities than just a centralized one also creates, in my opinion, some kind of a safety net. And what I would say is that we need to try to really enforce and see how the consistency and cooperation mechanism of all these data protection authorities under the umbrella of the European Data Protection Board works in practice. And if this fails, then I think we can indeed reimagine data protection law and think of a single data protection authority at European level. Thank you.
Thank you. And Arletta, now, Arletta, are you here? Okay.
Hello.
Hello. We have a question for you. A question? Oh, your opinion about data monetization. You can read read the question here.
Yeah, so what is my opinion on data monetization and cookie walls? Do we need precise rules and by whom? So this is really, thank you very much, amazing question. Like, this is really a very delicate subject for us competition lawyers and also for data protection. So obviously, like, I can't add too much about the data protection law because on the basis that I'm a competition lawyer. But what is my opinion on data monetization? So basically speaking, for any data being collected and for any cookies being obviously collected as well, I always picture it in the sense of we have a vicious circle. So obviously we access those websites, we consent to give away our data because obviously this is the terms of condition that they are offered to us, and those platforms manage to get the data from us, and it's fair. However, the one single data is from us, let's say from myself, is worth nothing. But when they collect the data from everyone my age or for everyone with the same interests as I have, they can genuinely collect the data, create the profile, and offer us the advertising. That obviously helps them to get much more money, and obviously then obviously there's a fine line between obviously innovation and breaching the privacy. Do we need the precise rules? I would say that certainly we would always need rules, because at this present we really navigate through a very uncertain area. We do know that obviously incidental consideration of GDPR and its breaches could form a competitional theory of harm, and we know that it can take a form of exploiting the users through unfair terms and conditions, through exploiting our data, and also through offering us any products with a very lower quality. But they can also exclude other competitors from the market. And do we need precise rules? We do have we do have obviously the DMA and DSA being offered, and DMA is a quite interesting tools for us to see how we can navigate through obviously those uncertain times. Who can offer the those rules? I would say that we need definitely a EU level type of protection. However, obviously I'm speaking from Glasgow, so I'm in Scotland. So from perspective of Brexit here, I would assume that Competition Market Authority together with the UK government needs to be in a close consideration and cooperation with EU at this level to make sure that obviously countries outside are also certainly kind of protected. But speaking from a European Union ground, they need to definitely be offered from European Commission. I hope that answered the question. Thank you very much.
Thanks to you. And Marco.
Yes.
Okay.
Yes.
We have two questions for you.
Yes.
So,
what are the problems?
Blockchain.
Okay. The first. Well, to the identification of the data control in a blockchain, the problem are several for me. Identify the data control in a blockchain requires remembering, for me, the distinction between private and public blockchain. Because in private ones, it would seem easier to identify data controller because since access is bound to the authorization of certain precise parties. Therefore, there would be a kind of centralized governance which fits well with what GDPR require. In the public blockchain, where everyone can participate and interact with with constraint in a peer-to-peer protocol scheme, it is not possible for me to find a single point of control of the ledger, and so a single data controller. In my opinion, the argument of those who exclude that, for example, miners are data controller is supportable because the controller must determine the purposes and means of processing tasks that are outside the precise activity of the miner, who merely performs the task and receive the payoff. Qualifying as a mere passive subject in the chain, in the technological chain. And moreover, if such a possibility were allowed, it would be very difficult for the data subject, for example, to turn to the totality of miner to assert his or her rights, a grant from GDPR, given, for example, to the difficulty of knowing the real number and the identity of the miner and the nodes on the ledger. For the same reasons, the argument of those who claim that data controller could be the developers, for example, of the protocol, of the blockchain nodes protocol, seems easily surmountable because these, in fact, are only concerned with the building technological infrastructure for other users, and that's it. Finally, there are those who assert that the data controller are the user, those who actually perform only the transaction in the chain. In that case, if the user uses the blockchain for personal purpose in any way, the GDPR for Article 2, Paragraph 2, letter C, for example, should not apply, because we would have the so-called domestic processing. About the second questions about ethical blockchain, if I remember, I think is a topic still unaddressed, but is very, very interesting. In fact, blockchain practitioners should work toward standardizing guidelines for ethical research, because studying cryptographic networks such as probing and disclosing a security vulnerability, the user can put money and tokens and NFTs at very risk. For example, as an interesting survey I read about, sponsored by Cornell University Research in LinkedIn, where they ask whether it is ethical to assign to university students as a study assignment research, for example, in informatics, a vulnerability in an operational blockchain smart contract, for example, in Ethereum smart contract. 2/3 of the respondents said yes to this. And traditional cybersecurity research, for me, faces similar dilemma, but so do legislators. For me, one must indeed move forward with the goal of creating an ethical culture of the use of blockchain technology in all fields, including the ethical one.
So, Marco, we have a consideration from Elisabetta. Yes.
Thank you, Mark. Indeed, an interesting and urgent topic. It looks like the blockchain technology, not privacy by design. Yes, it's true. It's true. Now, more blockchain are not compliant for me with the privacy by design principle, and it's very difficult to apply this principle. Yes, thank you, Elisabetta.
So, we have a question for Olga. This is the question.
Yeah, I'm reading it. So what do you think of the difficulty that many jurisdictions have in correctly identifying the damage caused by invasion of privacy and its compensability? So thank you very much for your question. I think that that's not so much related to exactly what I was presenting before, but of course can somehow touch to what we were discussing, that there's this divergence with respect to how data protection authorities provide guidance that can be used by data controllers and data processors. Of course, there is some discussion as to how to calculate properly material damage or non-material damage, and there are different opinions about that. What is the best way in order to protect the data subjects' rights in this respect? But I would say that there is more and more discussion as to how to better address this. And I do see also, I recently actually was reading a paper by a colleague, I don't remember the name, that was specifically about the non-material damage and how can this be and damage to personality rights. Which is also more relevant to actually what I'm working on my PhD research, which has to do with the accessibility and persons with disabilities and data protection law. How do we assess their damage that is caused due to lack of transparency that we still see even after all these years of the GDPR being implemented, that this is something that is very rarely addressed. So yeah, I think this is some first thoughts I have on this question. I don't think I have something more to add, but yeah, I'm happy to discuss further later if something else comes to my mind.
Thank you, Olga. And hope we have a question. Arletta?
Yes, hello.
Okay. Some data company.
So, with some data companies are accused of operating a monopoly regime. In this case, are the risk for consumer higher? That really depends, because essentially competition law, especially Article 102 of Treaty of Function of European Union, it really tells us that we should intervene when there is a direct breach to competition law. So when obviously we have a solid evidence of consumers being exploited or market being somehow market functionalities being somehow disturbed. So if we have just a company that is monopolist and they do really nothing to harm the market, or we don't have evidence that they do harm the market, then obviously we can't really intervene and we can't really accuse this person of accuse this company of actually harming the competition on the market. However, in the instances where we do have a solid evidence, like when we had with the Facebook case in Germany in 2019, that obviously we know that they were monopolists. We know that there were literally no platforms that could compete with Facebook, on a basis that if you compare Facebook with YouTube, on YouTube you can only post a video. When you compare it with Instagram, on Instagram you can certainly only post a picture. When you want to compare Facebook with Twitter, again, obviously there are limitations in how long your post can be when you speak about the characters being involved. Facebook has just been a one wonder company that combines all of the potentialities in the market. And lastly, also if you try to compare Facebook with LinkedIn, which seems to be offering the same kind of service as Facebook, again, you couldn't have done so. And on the basis that LinkedIn is certainly for professionals rather than for based daily conversation or like keeping in touch amongst your colleagues and friends. So obviously Facebook was one wonder. There weren't any companies to compete with Facebook, and that was fine. However, Facebook was involved in giving us, the consumer, terms of condition that were prejudicial to us. And this is where we had the risk for us being higher. on a basis that certainly we were unaware that Facebook was merging all the data combined with their platform and also any other third parties. And also, if we really wanted to switch to different providers, we couldn't have done so on a basis that firstly, there weren't any platforms that was offering the same kind of service, and on a basis that obviously we were quite locked in because our friends were there, almost our life shifted to Facebook to be there. So in this instance, the question as to whether there are risks for consumer hires, the answer will be yes and no, but that really depends on the circumstances involved. Thank you.
Thank you to you. And we can start with the second part of this conference. Pietro?
Hello. Good afternoon, Simone. Good afternoon, everybody.
Are you ready?
Yes, Thais and myself are ready.
Okay. Who will start?
Thais will start.
Okay.
I will start. Okay, can you hear me well? Let me know if there's any issue. So good afternoon, everyone, or good morning, good evening to those who are not in the same region as we are. So today, Pietro and I were going to discuss our contribution, which is about assessing risks involved in the use of AI systems. So we're going to discuss some of the current approaches that we have and also future approaches. So my name is Thais Fernanda Blaut. I am a PhD researcher in the Netherlands at the University of Groningen on the topic of AI and international relations, where I focus on autonomous weapon systems. Pietro maybe can introduce himself a little bit later when he talks about the second part of our contribution. So to start, I would like to address some of the issues that we have with the risks of artificial intelligence. Maybe many of you are already very much familiar with it, but I think it's always worth discussing what is the baseline, why this topic is so important, and why we still need to discuss it and progress in many ways when it comes to artificial intelligence. So we do have these systems all over the place now. It's in everyone's mouth, especially now after ChatGPT and GPT-3 and all those systems that have been so much discussed and that are already being so much used by everyone. So we have this type of technologies in all sectors of society these days. And the risks, they come with the development of technologies. I think that's usually how history presented technology development. So we have to learn how to deal with these new challenges that are coming up at this moment. So AI is also one of these things that we call dual use technologies. So we have systems that can be used in different ways. So for example, even a system that is developed for a civilian application could be later on used and deployed in military systems as well. But we also have this idea that a system that can be developed for with very good intentions and for very good uses can also maybe be used in ways that were not predicted by malicious actors later on. So the thing is that we also wanted to explore this aspect, that why we are still talking about AI and why this is still important. And we want to also break this idea that it's just about the hype, because usually there's a lot of people that try to diminish the importance of this discourse, these discussions, because it's so much hype, and maybe it is, but there's also some truth to it. There's also some basis for the concern. And one that is linked to AI in particular is how much this technology can spread. It can be reach a much larger scale than maybe previous technologies, and also have this scale and reach that indeed makes a difference and cross borders. So coming back to the risks then, we are trying to explore two different types of risks, and this is based on a paper that I worked together with Professor André Sitter and Dr. Oscar Strein. And in this paper, we divided the types of risks that we have nowadays into malicious use of AI and malicious abuse of AI. So the malicious use of AI would be the use of AI to enhance, enable, or augment acts that are committed by individuals or organizations, which can include certain crimes that are prescribed in legislations, but also it could be much more than that. For example, fake news or the spread of fake news or creation of fake news might be some sort of crime in certain legislations, but not in others. But this is still a type of risk that we want to talk about. And then we have the malicious abuse of AI, which includes problems and vulnerabilities that AI models themselves have, such as unintended AI outcomes, for example. And then we have, also when talking about risks, how can we regulate them? There are different types of approaches. Each different kind of country and government and organizations can decide and maybe use them, combine them, or just use one of the approaches to create new legislation. And this also has implications when it comes to ethical aspects of the technology. And we have an abundance nowadays of ethical principles, ethical documents, companies coming up with their own protocols and all of these things. And we know that there is a set of principles that are usually appearing in all of them. But also we wanted to highlight that having ethical principles and ethical aspects being considered does not mean that these companies will indeed follow that by the book, because it's not a legislation, it's not something that can be really enforced. So we are still indeed advocating that this is important, legislation is still important. So with the argument that it could stifle development of technology, might be not a strong enough argument when it comes to what consequences we could have with the malicious uses of these technologies. So maybe now I will hand the microphone to Pietro, so he can explore some of the other issues that we wanted to discuss with you.
Okay, Pietro.
So, what we would like to address also in our paper is some of the common aspects of the GDPR and of the Artificial Intelligence Act in relation to the methodologies for assessing the risks. Both regulations are based on a risk-based approach. So this is an aspect which is very common. And as of today, considering AI systems, we already have a tool which is very effective since the GDPR entered into force already 5 years ago. So the use of AI systems started a long time ago. So using this methodology when personal data are processed, of course, is possible already. And certain aspects have to be considered when carrying out this kind of assessments. In particular, the use of algorithms imply the use of different data. So this data can be categorized in following different names, and the Artificial Intelligence Act uses certain definitions, but in general, there are input data which are necessary to start the processing activity, which is necessary to make a prediction, because the output of an AI system is, of course, a prediction about the future, but also about the present or about the past. Also, training data are fundamental, and feedback data as well. So considering these different categories in the context of the assessment can be a possible criteria that can be used, also because the DPA assessment, which must be carried out pursuant to Article 35 of the GDPR, leaves open the possibility to consider additional criteria other than those which are expressly listed, and also to apply this methodology also to different cases. And in general, supervisory authorities are considering necessary this kind of assessment when artificial intelligence systems are used to process data. Some aspects which must be considered also while performing a DPIA in the context of the use of an AI system is the quality of the datasets. This is extremely important. The possible risk connected with bias and discrimination, with the erosion of human agency and autonomy. Also the fact that other fundamental rights like the freedom of expression and the right of information are relevant. The respect for data protection and privacy, which are fundamental rights pursuant to the EU Charter of Fundamental Rights. In general, all the matters and the issues connected with safety and security. So the DPIA process is an ongoing process, so it shall be carried out before the data processing activities start, and also during the course of the processing activity. So this is something which is provided also by the AI Act. So when considering the AI Act, it should be considered that we are still talking about a draft regulation. So it is still subject to comments of the European Parliament and of the Council. So before having a final text, other months, so we will have to wait the final version. In any case, under certain articles, which are Article 9, Article 11, and Article 29, Article 13, there are a number of provisions of the AI Act that read into combination allow already to make some considerations about the steps that must be followed when it comes to assessing the risks connected with the use of an AI system. So also in this case, also under this perspective of the new draft regulation, this assessment is a continuous iterative process, which should be started at the very beginning. So when the system is built up, so also considering a GDPR perspective, as if it was a by design and by default principle. And it must be carried out also if some relevant and significant modifications have to be taken into consideration. Another interesting aspect is that the European Union legislator, so the Commission, already carried out ex ante a kind of assessment. So listing the AI systems which are considered prohibited and which are listed in Article 5, and also listing the high risks, the high risk systems which are listed in Annex 3 of the draft regulation. A kind of assessment has already been done. But in relation to high risk systems, the regulation requires a number of activities that must be carried out. So there is also a reference to the DPIA that must be done pursuant to Article 35 of the GDPR in the AI Act. So all the elements which are listed in Article 13 of the draft AI Act must be considered in the context of this assessment. It is also necessary to adopt a technical documentation in order to demonstrate that all the security measures that must be adopted in connection with the risks which are identified while performing this assessment are mapped and considered and addressed with adequate measures. So we can see that there are not significant differences, at least in the approach. So our conclusion when Thais and I discussed about these different approaches is that basically the current methodology will not, it will still be useful when the AI Act will be approved and will enter into force, since the two methodologies are really intertwined and combined, and both are relevant and must be considered when it comes to processing also personal data in the context of the use of AI system. Thank you.
Thank you, Pietro. Thank you, Pietro. And now, Helena, are you ready?
Yes.
Okay, so we will start.
Okay, thanks.
Let's go.
Good afternoon, everyone. I would like to thank the organizer for the opportunity. Today, I will talk about the human dignity in the digital age, specifically the protection of women's privacy and the phenomenon of revenge porn. The rapid development of digital technologies is bringing many improvements in our daily lives, but it also raises significant concerns about privacy and human dignity. New technologies have brought new privacy violations, including, for example, revenge porn, blackmail, and online hate speech, which imply significant risks to both online and offline communications. Such types of abuse can cause serious harm to individuals, particularly to young women and marginalized groups who are often targeted more and more frequently and more severely than other groups. New forms of online gender-based violence facilitated by the use of information and communication technologies are a global concern. In fact, rapid digital and technological development, including the implementation of artificial intelligence, will inevitably give rise to new and different forms of cyber violence against women, with serious individual and collective implications worldwide. An European survey conducted in 2014 found that 1 in 10 women in the European Union report having experienced cyber harassment since the age of 15, including, for example, offensive sexually explicit emails or messages, or offensive inappropriate advances on social networking sites. The same research says that up to 90% of revenge porn victims are female, and that this number is increasing. In fact, during the lockdown, the revenge porn helpline, part of the UK Safer Internet Centre, says that the number of reports of revenge porn has gone through the roof during lockdown. The helpline, which was set up in 2015, saw a 98% increase in cases in April 2020 compared with April 2019. I have to say that there are a range of different terminologies used to describe this phenomenon, including gender cyber hate, technology facilitated violence, online violence against women, and online misogyny. Online misogyny, or the synonym cyber misogyny, is, we can say that is an umbrella term for all the kinds of negative experiences that women can go through online because of their gender. Individual harms deriving from gender-based infringement of privacy may range from reputational impact, discrimination in employment, stigmatization, social isolation, physical danger, arrest, and in some jurisdictions also execution. Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms proclaims the right to respect for private and family life. It states that everyone has the right to respect for his private and family life, his home, and its correspondence. Article 8 imposes respect even between private parties, and for this reason, it's important to evaluate the eventual state's adoption of measures to assure the effective protection of those. Private life is a broad concept, incapable of exhaustive definition, which might embrace multiple aspects of person, physical and social identity. The protection of personal data is an essential requirement for the enjoyment of the right to privacy and other fundamental rights and freedoms. So we can say that there is a positive obligation on the state to provide an effective deterrent against serious and grave acts. Particularly, the state is responsible if it fails to enforce the necessary measures to protect victims when the risks of violence are known. Article 8 includes the protection of personal data, physical and psychological, as well as one's sexual life, as broadly interpreted and applied in the jurisprudence of Strasbourg. The protection of personal data is very important for the individual's enjoyment of the right to respect for private life. The principle is that Article 8 affords protection to personal information, which individuals can legitimately expect should not be published without their consent. So we can say that, for example, the non-consensual dissemination of intimate images clearly concerns a matter of private life. And so in this case, it's very important the guarantee offered by Article 8. One of the most recent cases of revenge porn in Italy is that of the young kindergarten teacher in Turin. Her boyfriend spread via WhatsApp chat between friends a video of them in an intimate context. The chat also included the father of a little girl attended the teacher's kindergarten, and obviously the video was sent to other parents and the headmistress. The teacher was judged to be unprofessional, and the headmistress forced her to resign instead of defending her. The issue of revenge porn inevitably affects the fundamental right to privacy, as well as the victim's honor, reputation, and freedom of sexuality. In Italy, the Data Protection Authority plays an important role. In 2021, law number 205 introduced the new article 144 bis of the Privacy Code. The article states that anyone, including minors over the age of 14, who has well-founded reason to believe that images or videos with sexually explicit content concerning him or her intended to remain private may be sent, delivered, transferred, published, or disseminated without his or her consent in violation of the Italian Criminal Code, may contact the Data Protection Authority by means of a report or complaint. The new article can be considered a very important step for the protection of victims, even potential victims of the revenge porn. From a survey carried out by Women for Security, a community of Italian female cybersecurity professionals, emerged that about 50% of victims of revenge porn decide not to denounce it, and the reason of this are similar to those concerning victims of other sex crimes. So shame, the fear of being judged, anxiety about the judgment of family and friends, and the burden of criminal proceedings. This consideration allow us to understand how important is the work of the Data Protection Authority, Actually, the Data Protection Authority has faster procedures than judicial ones. Moreover, cooperation with the public ministry makes it possible to maintain a kind of contact between the proceedings of the protection of privacy and those for the repression of criminal conduct. In conclusion, we can say that online attacks disproportionately target women and frequently include detailed fantasy of rape, as well as reputation-ruining lies and sexually explicit photographs. If dealing with a single attacker's revenge porn were not enough, arising posts that make their way into social media sites often feed one another, turning lone instigators into cyber mobs. As Citron said, cyber harassment is a matter of civil rights law and legal precedents, as well as social norms of decency and civility must be leveraged to stop it. Thank you.
Thank you, Elena. Okay, so it seems that we have some question. Elena, we have some question for you.
Yes.
The first.
So is the current legal framework insufficient for the protection of the target groups you mentioned in the paper? Is the problem a matter of law or its enforcement? Well, in my opinion, the current framework might be sufficient, although the violations I mentioned earlier are characterized by the fact that they take place online. The internet is constantly evolving, and so the remedies to stop this kind of violation should also evolve quickly. So in conclusion, I think that I certainly do not think it is a problem of law, but rather a problem of law enforcement.
So, and we have other questions. The second one.
Do you think consent is still central in our society for data protection purposes, or is the interest of organization or states given priority? I think that it is not a normative problem. I think that the consent for the publication of personal data is still essential. So we should evaluate on a case by case the possible priority of states over the protection of individuals' personal data.
And the last question.
The introduction of the Article 144 bis of the Privacy Code is really a real step forward for the protection of privacy. Well, I think that the introduction of the new article can be considered a step forward. The problem is not that. I think that the problem is in the society. In fact, the victim of this kind of crime are ashamed, afraid of being judged. So I think that it's, as I said before, the work of the Data Protection Authority can be very important in this case, because the most the reason that the reason why the people decided to not denounce the violations are basically the burden of criminal proceedings.
Okay, thank you, thank you.
Thank you.
The privacy code, the Italian privacy code.
Yeah, of course.
Okay. So, we have a question for Boccaccini from Pietro. Pietro?
Yes, I'm here. I cannot see the question
I
yet.
cannot see you. Wait a moment. Wait. Oh, okay. Now?
Yes.
Okay. And this is a 1 million questions.
Uh-huh.
Good luck.
Thais, it's for you, I guess.
No, I
Yes.
think that it's for you. I'm sure this is for you.
If you want to go ahead, Thais.
Well,
If you
perhaps
prefer.
I can give some comments on this. Yeah, that's indeed a good question. I think that with all the procedures there started building up a few years ago at the EU level regarding regulation of AI, there was a very important document and a discussion regarding the ethics guidelines for trustworthy AI. And this document was prepared by this high-level expert group on artificial intelligence. And I can understand that this document was also forming the basis of what was later proposed as the AI Act. So I would say that the ethical concerns, ethical implications of artificial intelligence, and all these principles were thought of as a first step to the regulation. So I'm not sure we can say or think too much now what are the ethical implications of the regulation, because the regulation was also built up based on certain ethical principles. So I would say that it's a little bit the other way around. I'm not sure what could be the ethical implications indeed of a regulation. I would expect it to be on a positive note, because they have taken into considerations all these things beforehand.
I totally agree. I would have, I see it the same way. I mean, it reflects this draft regulation, an ethical approach to this, to the matter of the use of artificial intelligence, which is something unique in the global framework, I would say, since as we know, in the US, in China, we can see the use of AI systems which are not regulated, and this unregulated use of AI brings to some very some uses which are very difficult to conceive under a European Union perspective. If I think about the case of clear AI in the US, which has been forbidden in many European countries by supervisory authorities, or the use of biometrics data in China carried out through the use of AI systems. So the fact that there are fundamental rights and ethical principles and some common rules in all the European countries brought to this regulation, and it's very difficult. I mean, the fact that different versions of the regulations have been made, and that now we are discussing in the different seats of the European Union institutions, reveal the fact that the principles are common, but since we are talking about a very complex technology, and it should be as much as possible technology neutral, this regulation, addressing all the possible issues, it's very complex. But I think it's very important also for companies using these kind of technologies and systems to have some rules. I think that also the economical environment will benefit of having some new rules in this respect.
So it seems that this is your lucky day. We have another question for you. Very simple. I think that Pietro, you can give an answer.
Yeah, no,
Very easy.
yeah, no, for sure, the matter of transparency is fundamental. It is of paramount importance also nowadays, considering the current legal framework, but also in light of the AI Act. It's a matter that has been addressed by the regulator, by the Commission again. So it's very important that that users, customers, data subjects, we don't care about in this moment about the definition, but in any case, people whose data are processed through an AI system are well informed about what is happening with their data, and which is the which is the logic under the algorithm. Otherwise, the risks are increasing. So it's not only a matter of transparency, but also it's a matter of managing risks, because before drafting a privacy notice, a data controller should have carried out a number of other activities in terms of security and organizational measures. The matter, for instance, of data retention should have been addressed before, etc. So the notice about how data are processed is just, let's say, the tip of the iceberg. Below, there should be a very relevant system in relation to how data are, if data are securely processed. So yes, it's very it's a crucial point, and so probably now, in the context of the use of AI systems, the matter of transparency has not been addressed in the best possible way. There should be an increase also reading the privacy notice of ChatGPT and OpenAI. Certainly, it's not very simple to understand how data are processed.
Okay, thank you, and catch other questions. Wait a moment. Pietro and Thais. Wait a moment. Pietro. Or Thais is the same.
Yeah, maybe I can jump into this one. Many of the risks of AI stem from their unintended effects. Could you please clarify why didn't you consider such risks worth to be mentioned? And actually, we did consider them. They are indeed under this umbrella of malicious abuse of AI. We do consider them a vulnerability of an AI model. So we have seen over the past years many types of examples of unintended AI outcomes, and this is something that needs to be considered as a risk. And also, it's important that it is considered a risk by software engineers and people working in engineering teams when developing new algorithms. So there was one paper that I read by a Google team that was developing the smart response tool for Gmail. So when you start typing an email and they suggest the rest of the sentence for you, so the team working on that kind of tool, they were aware, for example, of possible unintended AI outcomes of that kind of tool, because it was using people's emails as well to train the model, and using that type of data to train that type of tool. So they thought, okay, we have this kind of risk, so what can we do to avoid that personal information from other users are leaked in this type of situation? So for example, they decided that one of the rules was that only when the term was used a lot by many users, then that would enter their data set for training the AI model. To avoid, for example, me typing my social security number is, and then giving the number of a social security number of another user. So this has to be considered as something that an AI model could be risky to people. It could be abused in a way that is intended or unintended. So we do consider that into this category.
Okay. So another question.
Maybe I can also, yes, I can also go for this one. So I understand that omnibus and sectoral are usually opposed. I'm not sure why you consider risk-based as a third way. Could you perhaps clarify what you mean? So it's not necessarily that they are free ways that need to be applied separately. They can be combined. They can be, for example, we could have a sectoral approach that also considers risk-based approach, and the legislator can indeed use all these types of tools they have in order to construct and to build this type of legislation that is completed and that is attending and really caring for all the issues that they are concerned with. So we do not consider that they are mutually excluding each other. They are different types of approaches that can be used in different kinds of ways. I would say that.
So now we have a question for all the speaker. Wait. Okay. So who wants to start? I suggest Pietro, you can start.
Okay. In cases where data is used as a bargaining chip, paywall, or even AI fodder, can the dignity of users be impaired? Yeah, the concept of dignity, it's very well used in this context, since it should be really the basis of any considerations when it comes to processing data, and especially in the while using risky tools like AI systems. So the dignity is really the basis where the fundamental principles and rights of privacy and data protection, as they are provided by the EU Fundamental Chart of Human Rights, it's where they come from. So yes, I would answer yes in this perspective.
Thais, what do you think about?
Yeah, that's a tough question. Maybe when we are talking about EU, it's a little bit more clear that it could be indeed affecting human dignity, but I'm a little bit more cautious when it comes to worldwide understandings of human dignity, because also it can mean different things for people in different countries. It could be a relevant aspect or not. So I think that's the first thing to be considered. I'm actually working at the moment on another topic in another paper also about the impacts of the use of, for example, autonomous weapon systems on human dignity. And I'm already struggling quite a lot also to come to more objective arguments, because also human dignity is also this kind of umbrella term, this basis of human rights, but we do not have this very well-rounded definition, and we do not have very objective aspects to look into when we are discussing its infringement. Yes, I think that I would, my impulse would be to say that indeed dignity can be impaired, but then it depends on to whom and in what context and where, and many other things could be considered as well. So I wouldn't have like a very straightforward answer, but that would be my point of view.
I think that the problem is what kind of dignity? Moral dignity? Ontologic dignity? We don't know. And Marco, are you here?
Yes, Professor Bonavita.
Okay.
I think that is an interesting topic on several fronts that Pietro and Thais said. I think that legislative action is urgent needed, but there actually always step forward with, for example, for the digital single market regulation and other EU regulation on the point. It's very interesting.
Oh, Elena?
Yes, in my opinion, I think that when data are used as a bargain chip, well, the dignity of user can be violated.
Okay, so we have now some question for Elena. Are you ready?
Yes.
Okay. Elena, I don't see you. We don't see you.
Okay. Sorry.
Okay. Let's go.
I already answered this question.
Is the current legal framework insufficient for protecting the target group you mentioned in the paper? Is the problem a matter of law?
Okay. As I mentioned before, I think that the current legal framework might be sufficient, although the violations, as said before, are characterized by the fact that they take place online. So I think that is not a normative problem. At most, in this case, I would say that it could be a problem of our society that accepts certain behaviors offline as well as online.
So, second question for Elena.
Okay, so I think that we are talking about Article 8. I think that the consent for the publication of personal data is still essential. I think that we should evaluate on case by case the possible priority of states over the protection of individuals' personal data.
Okay, and the last question for Elena.
As already said, I think that...
Yes.
What?
Okay, we have given answer to this, correct?
Yeah, I already answered it.
Okay, so there are another question. It seems no. So if there aren't questions, we can close this session and see you tomorrow. Thanks to all the speakers, and have a good day and see you tomorrow.
Thank you, Simone,
Thank you.
and thank you, everyone. Goodbye.
Thank you to all.
Thank you. Congratulations to all participants and to all related.
Okay. Bye-bye.
Bye-bye. Thank you.
Bye.